Hello, hello, hello. Thank you once again for joining me here at Legalology 268. If you are viewing this video, then it is quite possible that you already have seen part 1. In part 1, we would have discussed what a bill was, and we would have also looked at the different types of bills. In today's video, our focus is going to be specifically on the parts of a bill. You will come to see as we go through this video that a bill has quite a number of parts, and these parts each have a distinct function that they play in the bill. If you were to look over here, you would see that we have the explanatory memorandum coming right down to the schedule. So for the remainder of this video, what I'm going to do, I'm going to explain to you what the functions are for the various parts of a bill. Each part of a bill is very important, and none of the parts are more significant necessarily than the other. However, the explanatory memorandum in any bill is quite significant, because generally what an explanatory memorandum does is that it provides a useful guide as to what is intended to be achieved by the proposed bill. It basically tells an ordinary reader what the bill seeks to do. In most jurisdictions, the explanatory memorandum is found at the beginning of the bill, but in some countries, it's found at the end of the bill. As you will see, it explains the background behind the bill. It states the objectives and the reasons for introducing the bill, and it provides an outline for the conditions of the law presently, and it explains why the passage of that particular bill will improve the state of the law. So remember our examples earlier when we were looking at litter, and we had litter bill and litter amendment bill. Let's say, for instance, we didn't have a litter legislation on our books, and the government recognized that littering was becoming a serious problem within the society. And having discussed it at the cabinet level and come up with a policy, they would have recognized that there is a need for having a litter bill. Well, after the bill would have been drafted according to instructions, the explanatory memorandum of that bill would explain the fact that, for instance, littering is becoming a large-scale problem. It would explain that there are no laws on the books to deal with the issue of littering, and that would provide a foundation, a reason, an objective for why the bill was being introduced. So as you can see, an explanatory memorandum in a bill is very, very important. It's practically the first thing you read about the bill before you actually read the bill itself. Now we arrive at the arrangement of clauses within the bill. When you think of the arrangement of clauses, I want you to think of the table of contents in a book. You know, before you actually start reading a book, right at the front, there's usually a page that outlines all the chapters within a book. Well, that is what the arrangement of clauses essentially is in a bill. It outlines every single clause or section within the bill, and these clauses, later on when you get to the body of the bill, they will be used as section headings. So let's look over here, for instance. We have on the arrangement of clauses section of the bill, we have here the first part says short title and commencement. All right. So when you actually get to the body of the bill, there will be a section heading that says short title and commencement, and then there will be words that basically state what the short title of the bill is and what the commencement date of the bill will be. Similarly, if we were to look at, let's say, Clause 5, procedure for a custodial interview, you would actually see a section heading in the bill with that with those words, and you would see some words beneath that that basically would tell you what a custodial interview is for a bill of this type. Right. So now we have arrived at the long title and the enactment clause. The long title of a bill is very important because it provides critical information regarding the purpose of the bill. As a matter of fact, the long title acts as a guide to the reader of a bill. Turning here, we see it says, an act to prohibit the practice of smoking tobacco products in certain areas, to restrict promotional activities which encourage smoking of tobacco products, and to provide for other related matters. This sentence right here is referred to as the long title, and we see from what is written in the sentence that the bill aims to prohibit the practice of smoking tobacco products in particular areas, to restrict any activities which encourage the smoking of tobacco products, and it will also provide for other matters which are related to the whole issue of smoking tobacco. So right there, having read something like this, you gain a clear understanding as to what the bill is going to be about. Now, the enactment clause usually states under whose authority the bill is made. Now, please remember that only the legislature has the power to make laws, and the legislature would be referred to as Parliament, or in some countries, the Legislative Assembly. I think in the United States of America, it's called Congress, that sort of thing. In this example we have here, it says, enacted by the Parliament of Utopia. That part there, this whole sentence here is the enactment clause, and Parliament of Utopia tells you the authority under which this particular act is made. Every bill contains what we commonly refer to as preliminary clauses. The preliminary clauses which are generally found in a bill are the short title, the commencement, and the interpretation or definition clauses. Concerning the short title, essentially, the short title is the official title of the bill along with the year in which the bill is being proposed in Parliament. So if we were to look at our example, you'd see here, short title. This bill may be cited as the Interviewing of Accused for Serious Crimes Bill 2015. Now you will notice that the words interviewing of accused for serious crimes, those words are underlined, as well as the year 2015. So these words are referred to as the short title of the bill, and 2015 would have been the year in which this bill was probably being proposed into Parliament. We see here also commencement. Basically, what the commencement clause does is that it informs the reader about the date or the possible time period when the bill, after it is passed and it becomes an act, when it will come into force. Now, generally, a standard commencement clause would be one like this. This act shall come into force on a date to be appointed by the minister by notice published in the Gazette. Now, the reason why you would see a commencement notice like this one is because generally after an act is passed, there may be some time that would be needed to put certain things in place before the act can actually become law and become binding on the society. So the minister would generally wait until an appropriate time and publish a notice in the Gazette which indicates when the act will actually come into force. There are, however, some commencement clauses in a bill that actually stipulate an actual date when the act will take effect, or a period of time which will have to pass before the act takes effect. Our final preliminary clause is the interpretation or the definition clause. This clause defines key words and phrases which are used throughout the bill. Generally, if a word is being used in a bill and the meaning of that word is not the usual everyday meaning that we know, but it is being given a different meaning, special meaning, a word like that will be defined in the interpretation clause of the bill. And if we look here, you see here interpretation, and it says in this act, and you have several words bolded, and you see a meaning, a definition, what the words mean. And the meanings that you would see in the interpretation clause, generally those are the meanings that are to be applied to the words as they are used throughout the bill. Let us now discuss the body of the bill. In any bill, there are several interrelated and interconnected parts which comprise the body of that particular bill. We are going to look at 4 parts at this point in time. Section heading or marginal notes, and you already know about that from our previous discussion. Basically, what a section heading is that it describes in a concise form the main object of the section to which they relate. So generally, the section heading, the words that are contained in the section heading will give you an idea as to what the section will be about. And speaking of section, a section contains one idea and it's usually one sentence. Further subdivision of a section would be what we refer to as a subsection. And in every bill, once you have subsection, you're going to have more than one. And basically what subsections are that they are related ideas which are outlined under a section. But what about the paragraph? Well, a paragraph is a further subdivision which contains a unit of thought when read together with the introductory and concluding words. Now in the slides that follow, you will see how all of these parts, how they would look in a bill and how they all work together to create what we call provisions in the bill. We now see here an illustration of what exactly a section is and how it would look within a bill. We have here presumption of inadmissibility. That would be a section heading. And you notice there's a number 7 in front of these words, which means this is section 7, and the heading of that section is called presumption of inadmissibility. Now if you come down here, what we see here are actually the words contained in section 7. And you see it says, subject to sections 8 and 9, a statement made by an accused during a custodial interview that is not electronically recorded in accordance with section 4 is presumed inadmissible in any criminal proceedings brought against the accused. Now remember, the section heading said presumption of inadmissibility. And when we read the words in the section, we recognized that if a custodial interview was not electronically recorded, then that particular interview could be presumed to be inadmissible. So you will notice that the section heading basically tells you what the section itself is going to be about. So it's very important that the section heading and the actual words in the section correspond with each other. We now have an illustration of subsections. Now we're going to go back up here again. We know this is our section number. This is our section heading. So section 6, section heading states procedure for a custodial interview, and we have here some subsections. Now, the way in which you can identify a subsection is that usually the subsection is represented by a number, and the number is contained in parentheses. So we have here 1, we have here 2. So on the section 6, we have 2 subsections, subsection 1 and subsection 2. And each subsection basically would link back to what is in the section heading, and usually a subsection would be talking about one specific thing. So for instance, it says here, the guidance set out in the second schedule applies to the procedure for electronic recording of a custodial interview. And in subsection 2, it says, if required, an interpreter may participate in the custodial interview by remote communication. Now you will notice that both of these subsections are speaking about the whole issue of a custodial interview, which we see reflected here in the section heading. It's just that each subsection is speaking about a specific thing as it relates to the custodial interview. So subsection 1 makes reference to the guidance as it applies to recording a custodial interview, and subsection 2 basically lets us know that an interpreter can be a part of this custodial interview, and they may do so by remote communication. So we have some information as to how a custodial interview ought to be conducted, and this is in keeping with the title, the section heading of section 6, which says procedure for custodial interview. We are now going to look at paragraphs and sub-paragraphs. You will recall that earlier I mentioned to you that a paragraph was basically a further subdivision which contained one idea when it's read together with the introductory and concluding words. In any bill, if you see a paragraph, or if a paragraph is contained in a bill, you will be able to recognize a paragraph, because a paragraph would generally contain, or it would start with lowercase letters contained in parentheses. So we see here from our example, we have a paragraph A and we have a paragraph B. Now you already understand what the section heading is all about. It says here, rebuttal of the presumption of inadmissibility. You know a section, and we see here a presumption of inadmissibility under section 7 is rebutted if the court finds. And so now we are going to look at a further subdivision of the section, and that is what we refer to as the paragraph here. In this case, if the court finds that A, the statement is admissible on the applicable rules of evidence, or B, that the statement is proven beyond a reasonable doubt to have been made voluntarily and is reliable, and either. And further down we see here Roman numeral 1 and Roman numeral 2. Now any further subdivision that you would see under a paragraph which contains Roman numerals in parentheses is what is referred to as sub-paragraphs. Essentially, what the sub-paragraph is, it's a further subdivision of a paragraph, and it expands on the thought expressed by the previous paragraph. So in this particular example, we have here paragraph B, and paragraph B contains subparagraph 1 and subparagraph 2. The information contained in subparagraphs 1 and 2 is a further division and extension of the thoughts or the idea expressed in paragraph B. So let's take a look now at parts and divisions. Parts are used to divide a bill which is considerable in size. An act is divided into parts the same way a book is broken up into chapters to assist in improving the readability of the act. Now, one of the good things about having parts in a bill is that it provides a very clear picture to the reader as to the different sections that would be located under a part. So let's look at our example. We have here Part 1, licensing of marketplaces and ancillary facilities. And we see the different clauses, Clause 3, licensing, Clause 4, grant of application for licensing, coming right down to Clause 7, which states revocation of a license. So what we do when we have a part in the bill is that we have the part number, the title of the part, and the various sections that are going to be contained under that part. But let's take it a step further. Division. A bill may be further divided into divisions within a part. Divisions are really only used for bills which are very complex and which deal with a lot of issues. So coming back to our example, we see on the Part 1, we have Division 1 and Division 2. Division 1 speaks about licensing, and we have all the sections that are speaking about licensing. And Division 2 speaks about securities exchange, and we have here Clause 8, delisting of securities, Clause 9, disciplinary action over members of a securities exchange, and Clause 10, closure of securities exchange in emergency. So although we have a part that says licensing of marketplaces and ancillary facilities, we have division which further divides the information, and each division speaks to a specific thing. So Division 1 is speaking about the issue of licensing, and Division 2 is speaking to the issue of securities exchange. A schedule is very important in a bill. And I know you're probably tired of hearing that this is very important and that is very important in a bill. But it's true. And the reason why a schedule is so important is because schedules provide details that are essential to certain provisions of the bill. Generally, there are two types of schedules that you may see in a bill. One, there are those types of schedules that contain material that cannot be put into the form of sections, for example, and you would see things like a table could be a schedule, a diagram, a list, even a map. In the example we have here, we have a list of serious crimes: money laundering, murder, manslaughter, kidnapping, human trafficking. So obviously, the legislation that this particular schedule was contained in, on the Section 2, reference was made to serious crimes in the first schedule. And so now that you've come to the part where there's a first schedule in the bill, you see a list of all the serious crimes that Section 2 would have been talking about. Another type of schedule is the type of schedule that reproduces an agreement that the executive has signed on behalf of the state. So let's say, for instance, we signed a treaty. Our country became a party to a treaty and we signed that treaty. In most instances, a bill would have had to have been prepared in order for the provisions of that treaty to be incorporated into our local or domestic law. And in a bill like that, the agreement that was signed by our government would be included as a schedule to the bill. And we have come to the end of this video. Please, if you haven't yet done so, subscribe to my YouTube channel and press the bell icon so you never miss any new uploads that I will do in the future. Thanks for watching.